Joining us today. We're lucky to have tax attorney Jason Silver here to speak with us about various tax issues that pertain to our bankruptcy practice, both before and after filing. I don't know about you guys, but I often say I do not give tax advice. And when I say that, my follow-up referral list always has Jason on it. So we're happy to have him here. Just a little housekeeping before I turn it over to Jason. If you would please make sure that your name, not your telephone number or anything else, is on your Zoom sign in. That is for CLE credit purposes. The session, as always, is being recorded for members' future viewing. So we do ask that you please keep your microphones muted during the presentation. You are welcome to type any questions or comments that you may have into the Zoom chat box. That way we don't have the presentation. If the question or comment is super salient or a clarification point, we might interrupt Jason just to share that or pass along that question. But otherwise, we're probably going to keep most of the questions and comments for open session at the end after Jason's done with his presentation. The materials for today's session are posted on the ACBC website as always, and I will place them in the chat here in Zoom in just a second. Toward the end of today's session, I will also post the CLE certificate here in the Zoom chat. That is the only place you're going to see the CLE certificate. So we will verbally announce that it's been posted in the Zoom chat. Please be sure to grab that CLE certificate when it is posted. I'll post the materials periodically throughout the presentation here because those who join late won't see prior chat messages. If for any reason you're not seeing the PDFs in the Zoom chat window, please let us know. You can type your email address into the chat, or you can send us an email at admin@acbcforum.org, and we can email those documents to you. And with that, I will turn it over to you, Jason. Thanks so much for being here.
All right, good afternoon, everyone. Some of you, I was clicking through the list of people that are here in attendance, and some of you I know, and I've worked with you in the past, and you probably already know my background, but real quickly, I didn't put my URL for my website. It's taxcontroversy.com. You can look at more of my background, knowledge, and experience in this area, but started my 31st year of practicing law, and as a former IRS attorney in Los Angeles back in the 90s, and now in private practice since 1999. Things have changed a lot in the tax area, and I'm not trying to make any of you guys tax attorneys or anything else like that, but there's certain things that I think bankruptcy attorneys need to know that I see pitfalls in your area that some of them don't pay attention to if you don't have somebody like myself that you brought into the bankruptcy. So we're going to talk today a little bit about tax debt before and after bankruptcy, maybe what some bankruptcy attorneys should know. This is not meant to be comprehensive, and some of you have heard me talk in other forums. Some of these areas I may have touched on different aspects, but I'm just trying to give you guys kind of a issue spotting, so you know what to look for next, or to call somebody like myself to help you with it. So if we can go to the next slide. Okay, so we've got taxes due before bankruptcy. We have income taxes, trust fund taxes. So income taxes, we all pretty much know what that is. That's your 1040 taxes. When you file your income tax return, hopefully you're filing your income tax returns. And as a lot of you bankruptcy attorneys already know, if you don't file a tax return, and the government files what's called a 6020B substitute for return for you, I believe there's case law that says that you can't actually bankrupt those taxes. So I get clients all the time to me and I say, well, one of your collection alternatives is bankruptcy. And look at me like, you can bankrupt taxes? I'm like, absolutely, you can bankrupt taxes. But I said, I'm not a bankruptcy attorney. I can just give you some of the guidelines on those. But if you're looking to file bankruptcy, I'll refer you to a bankruptcy attorney, or you can find one on your own. So we've got income taxes. I think we all know, like I said, we know what income tax is. Trust fund taxes. Trust fund taxes. So my example I always give people is, my first job was working at Bash's when I was 15 years old and bagging groceries. And I was getting my $3.35 an hour bagging groceries back in 1985. And I got my first paycheck, and I didn't get the full $3.35 per hour that I worked. And I went to my father, who's also worked in my area for over 50 years. And I said, Dad, what is going on? Why are all these deductions on my paycheck? And he says, oh, well, you got to pay your half of FICA Social Security and your federal and state withholding. And I'm like, oh, what's that? 15-year-old kid, I have no idea what this is. So he said, well, you got to, for your Social Security. So, when you start getting Social Security, and then your withholding. So when you file your tax return, you kind of prepay as you're going along. And I said, okay, well, how did those get? How does the government know that I have these monies? He said, well, you're the employer, in this case, Basha. He files an employment tax return, a quarterly Form 941, and on that he lists the amount of money that he withholds for you, for your FICA, Social Security, and for your withholding. And then when you go file your returns, the government has it; it's there. So yeah, it makes sense. It's great, but we all know if you're a business and you need to borrow money, it's really easy to borrow from the federal government by just not paying those trust fund taxes. Trust fund taxes, as you all know, not dischargeable in bankruptcy. So, and it's really due to the fact that these are monies that are held in trust, and these are monies that people that this 15-year-old kid should be getting when he files his tax return. And the government looks at it as stealing the money directly from the IRS because they're giving somebody else, that is the 15-year-old kid, credit for it. So next slide. All right, so let's talk about, we'll go more through these a little bit. So we got our 1040 taxes. 1040 taxes can be dischargeable. We got the 3-year, the 2-year, and the 240-day rule. So 3-year rule, generally 3 years after you have an assessment that's made against you, you can potentially be eligible for dischargement of those taxes. The 2-year rule is if you late file a tax return, you have to look at least 2 years from the date you file that late file tax return, or 3 years from the date the return was originally due to be filed, whichever is greater. So, a lot of my clients, they're filing, 3-4 years later. So we're just looking at the 2-year rule. But if somebody's filing, let's say 6 months or 9 months late, then you're going to probably be under the 3-year rule. The second thing is 240 days. So let's say you go through an audit and the IRS makes an assessment, you either agree to it or they make a default assessment against you. You have to wait 240 days from the date of that assessment. So, then that will be on all the IRS transcripts, which we're going to talk about in just a little bit. Like I said before, trust fund taxes, not dischargeable. Tax liens. The government, if they file those before bankruptcy. So I was a young lawyer, and one of my clients went into bankruptcy, and he had tax liens. And about 9-12 months after he came out of bankruptcy and got his discharge, I get a call from an IRS person. And the person says, yeah, Mr. Silver, I see you represent, Joe Smith. And Joe Smith, we're trying to collect on the lien. And I said, well, what do you mean? He got discharged in bankruptcy. And they're like, well, yeah, we understand that. But we filed a federal tax lien with Maricopa County before he filed bankruptcy. And that house that we've calculated he has $300,000 in equity in, we want that $300,000. And I was like, huh. And I looked into it. I'm like, they're absolutely right. They're entitled to that money, just like anybody else that had filed, a lien or something else against the property for their right to receive the monies from the sale of that property. So that was kind of a wake up call for me because I wasn't even aware of that, and we hadn't even looked at that issue because the client had filed bankruptcy and hired me during the bankruptcy. So it's really important that your clients understand that you look at the transcripts. You can get the transcripts from the IRS, or you can go to the recorder's office for your county to see whether or not a notice of federal tax lien has been filed, state or federal. Because if it is, once they come out of bankruptcy, the IRS is going to want the equity in that property, assume there is any equity that would possibly go to them. So that's a big issue. I see bankruptcy attorneys miss it all the time. Next issue is dealing with transcripts. Now, usually a lot of times the bankruptcy attorneys either request I get the transcripts or the taxpayers can get them through e-services. So transcripts are really important. And these are what usually we'll get what's called a literal transcript. And the literal transcript is going to show all the assessment dates for when the return was filed, and it's going to show assessments for maybe later audit adjustments, or sometimes a taxpayer will file an amended return and increase their taxes for things they may have left off. And it's also going to show the tax lien filing. So assessments are really important because you could have a return. Let's say you have a return that was filed on 4/15 of 2025. Okay, so that's going to be your first assessment date. But let's say they go through an audit and then there's an assessment on 4/15 of 2026. Well, that's going to be a second assessment against them. And there's going to be 2 periods of time that you're going to have to look at for purposes of determining the 3-year rule or the 2-year rule or the 240-day rule. So you need to take a look at the transcripts and see whether or not there's been more than one assessment. I see that get missed all the time. So always pull transcripts. Either have your attorney pull them, the tax attorney pull them, or have the client pull them through e-services. All right, next slide. All right, so we're talking about, somebody now they get their discharge out of bankruptcy, and so we have taxes that either we're usually dealing with taxes either the taxes haven't been discharged in bankruptcy for whatever matter. Maybe they're trust fund taxes, or maybe they had 5 years of tax returns assessments, and they really needed to get the first 3 done, and the second 2 they didn't care as much about because they weren't as big. So, or maybe their attorney or whoever helped calculate the wrong dates. So I talked to you, first thing was about the tax lien filed by the IRS prior to filing bankruptcy. We got installment agreements that we're looking at and what we're talking about is these balances that are now due after they come out of bankruptcy. So ways we can take care of those, like I said, we got the lien issue. We can look at installment agreements. We can look at currently not collectible, and then we can also look at offers and compromises. Those are the areas that we look at. So next slide. So I talked about this before, just to reiterate it. You're going to get a contact from somebody at the IRS, probably 9-12 months later, about the government's equity in your client's property or properties, if they got the filing done before the bankruptcy was filed. So make sure you get the transcript, take a look at that. Next slide. Installment agreements. So we have 2 different types of installment agreements. The first installment agreement we have is what's called a part pay. The second one is a full pay. Part pay, just like it sounds. So the statute of limitations for the IRS to collect against somebody is 10 years. Now, that period of time gets frozen while you're in bankruptcy for that period of time, plus they add on another 6 months. So this is also, we refer to this as the CSET, the collection statute expiration date. So under a part pay installment agreement, you would not pay off the balances that are due and owing. So I got a client we're dealing with right now. He owes about $3 million, and he doesn't have sufficient assets and income coming every month to pay off this $3 million before the statute of limitations expires in about 6 years. So the government says, okay, we're going to set you up for a part pay installment agreement, and we're going to do this based upon your ability to pay. So how do we determine what their ability to pay is? Well, the IRS has financial statements. For individual, it's a form 433-A. If it's a business, it's a 433-B. They're going to look at your assets, and they're going to say, okay, first of all, we need to see what assets do you have that you can liquidate. And the first thing they're always going to look at is your home. Do you have any equity in your home that you can liquidate and give that equity over to us? Now, taxpayers always say to me, well, I just came out of bankruptcy and, I was under the exemption amount and I got to keep the house and everything else. And I said, well, that's great. And that's a bankruptcy, but the IRS is going to look at all your assets. And they're going to look at these for purposes of what, if you're setting up an installment agreement, they're still going to want whatever you have in these assets. They're going to look at if you had a lot of equity in a car or cars. So you got a client that has 3 cars, one person. He's like, yeah, you're going to have to go sell 2 of your cars and give that money to the government. If you've got a lot of equity in, say, your 3rd car, and let's say you have nothing you owe on it, they're gonna want you to go get a loan on it. So that's cars. Retirement accounts. Even though those retirement accounts may have been exempt in a bankruptcy, they're still going to want you to liquidate those for them. Well, if you're not 59 and a half, you're going to get hit for what? A 10% early withdrawal penalty. You're also going to get you're going to have to pay your state and federal tax. So you could be as high as 37% at the federal rate, and then we have a 2.5% flat tax rate for the state. So you could be up to 39.5% in federal and state taxes, plus another 10% in early withdrawal. So you're almost 50%. So, usually when the government's looking at retirement accounts and stuff like that for liquidation, they'll allow you to keep 30% of it and apply those to the taxes. So what I always do with the government is I was like, look, let's do it assuming it's 50%. Let's take that 50%, we'll liquidate it, and then we'll have those monies withheld at the source. So when my client files his next year tax return, say 2026, he's not going to owe more money, and then we just tack it on to what they already owe. So you have to work with them on that. It can be a little bit sketchy with them in that regard. The difficult thing to really liquidate is kind of like interest in LLCs, partnerships, LLPs, whatever you might have. You have an ownership interest in privately held company, stock, whatever the case may be. And those are always difficult to determine because there's usually not a market for that. So usually we've seen where the government usually isn't looking for any kind of liquidation of those assets. But it's going to depend upon what the asset is. That is the interest in that entity. So those are the main things that they look at. Always ask your client, coming out of bankruptcy, assuming that, it didn't get taken in the bankruptcy and liquidated, is, do they have any precious metals? We all know precious metals have had a big run the last couple of years. Diamonds, and all those types of things, because the government wants to know everything you have. So assuming you can get a part pay installment agreement set up, a lot of times the part pay installment agreements we set up, like this guy, what I'm going to do for this guy that owes $3 million, he's not going to even be able to pay the interest on it with his part pay installment agreement. So, $3 million, he's talking about $210,000 a year just in interest at the current 7% rate. So, and his payment's going to be about $10,000 a month. So he's not going to be paying interest. So his balance is actually going to be increasing every month because he's not going to be paying even the interest. So what a lot of people don't know also in the part pay installment agreement, and the government will tell you this, but a lot of people gloss over it, is every 2 years, by statute actually, the IRS is supposed to ask for updated information and determine whether or not you can increase your payment. But on the flip side, what I will do, and I'll look at these for clients, is I'll be like, well, maybe you can not afford that $10,000 a month, but in my example, maybe you only afford $7,000 now. So I'll go back to the government and say, well, thank you for asking. We can't even afford $10,000 a month. Now it's at $7,000 a month. So use it to your advantage if you can. They never really like when we say that to them, but that's an issue. Full pay installment agreement, just like it sounds, full pay. You're going to full pay the IRS balance within the collection statute expiration date, the 10 years, whenever that date is, plus any tack on time. So, there's 3 types that you can get the installment agreements on their full pay. The first one is if you owe up to $50,000. It's usually pretty easy. You can fill out some forms and set it up with the IRS. They don't require a financial statement. They're not supposed to file a tax lien if one has already been filed. And they will give you up to 72 months to pay this off. as long as that is going to be before the statute expiration date. So they'll give you up to 6 years, but you got to look at it and make sure that we still have some time. But remember, you still have the tack on time. You've got the bankruptcy plus 6 months for the tack on time. Now, what my clients never understand is interest and penalties will continue to accrue until their balances are paid. So let's talk about what those are. The first penalty that you'd be looking at is a late payment penalty. So the government charges 0.5% per month, maximum 25% for a late payment penalty. So you're paying in essence 6% a year for a late payment penalty, and you're paying interest. Well, last year interest went as high as 8%, and now it's down to 7%. So right now you're paying 13% in failure to pay and failure to, and then the interest on that balance. So it's a pretty high rate. So I always tell clients, if you can borrow this money from somebody else and pay a lower rate, if you have an asset that may have been exempt in bankruptcy that you have that you can borrow against, and you're usually going to be better off. Because, also remember, let's say they have a 72-month payment plan. They got to make payments for 72 months, 6 years. Most of my clients are not very good at doing that. Even if it's under a direct debit, they'll forget to, have that amount of money in their account. Then the government goes to debit it, it's not there. And then we start getting letters of default, right back where we started. So the next type is where you owe over $50,000, but up to $250,000. The difference between up to $50,000 and then over 50, but up to $250 is the IRS will also give you this without a financial statement, but they're gonna file a tax lien against you if one isn't already filed. But they're also going to give you up to 7 years or 84 months to pay this off. So that's a benefit too. But remember, we still have that, it's got to be paid off before the statute expiration date, the 10 years plus the tack on for the bankruptcy, plus 6 months. If you owe over $250,000 due to the IRS, what's going to happen? You're going to, and people would call up the IRS and say, "Oh, I owe $350,000." Be like, "Okay," and the IRS would say, "Well, we're going to have to assign you a local revenue officer." So a revenue officer, for you those that don't know, is basically an IRS collector. That's all they are. They're just trying to collect money from you. That person, if you owe over $250,000, they're going to require a financial statement from you, and they're going to require you to liquidate all your assets. And then based on your financial statements, they'll set you up with either a part pay installment agreement or a full pay installment agreement, whatever the case may be. What we're seeing recently is because of a lot of people that got either RIF'd or took early retirement from the IRS, a lot of times now we're seeing some of them not even requiring financial statements. They're just like, okay, statute's going to expire in 72 months. That will require you to pay $6,000 a month for the next 72 months. We'll just set you up on that. You don't need to liquidate anything, and we can get to do that. So it's a lot easier. We don't have to go and liquidate assets. We don't have to provide all the financial statements and go in the back and forth. So it can save a lot of money on attorney's fees, and it can make it a lot easier on our end. Do we have any questions about part pay or full pay installment agreements? Anyone? Anything in the chat room?
Oh, there's a couple questions, but not on that topic.
Okay, so let's go on to the next slide. All right, so when you're filling out your financial statements, the government may look at something and say you're currently not collectible, also known as CNC status. Basically, you can't afford to pay the government right now. Okay, maybe you can in the future, but you can't do it right now. If you get placed in that status, it goes on the computer. You'll see it on the transcripts, and it'll say currently not collectible status. And when you're placed in that, the government doesn't take any active collection against you. That includes any levies or garnishments. Now, they can file a tax lien against you, and they usually will if they haven't already done that. but they're not going to go in and start levying your bank accounts or your brokerage accounts or those types of things, or garnish your wages. Remember, the levies that usually happen at the bank account levels or brokerage accounts, those are usually just one-time levies. So whatever's in the bank account that at that time when the third party receives the notice levy, that's what they're going to take it. They put into an escrow account for 21 days, and then 21 days they release it to the third party, that is the IRS. Garnishments, those are continuing in nature, just like they sound. They'll start garnishing your wages, and there's a statutory amount they can take. It's kind of a confusing formula. They'll put all that together, and they'll take it, and it's going to be a large portion of the person's paycheck. Probably going to put them in a situation where they can't afford their bills anymore. So that's the currently not collectible status. That's what happens with the levies and garnishments. But this doesn't erase your taxes. Okay, this just puts you in a situation where you just have some breathing room. So some people say, I just need some time. Now, if the person, for example, didn't go into bankruptcy, and the IRS doesn't file a tax lien, or there's nothing to lien against, sometimes this can get people into a place where, hey, we're not quite at that 3-year, 2-year, or 240 days. This can give us some more time so we can get to that point. So, sometimes it's a good stall technique if you can get your client put in this status. Sometimes they'll put your client's status for like businesses that are defunct. So they'll put in a status 53 out of business. So they want to see, I want to, provide me the last bank statement. If it's, registered with the Corporation Commission as an LLC or a corporation, I want to see that you've dissolved the entity. That's what they're looking for. And, then they can place you in an uncollectible status out of business. So sometimes we'll do that for some of our businesses because my clients don't want to keep getting IRS notices. They don't want people to keep inquiring on them. Maybe there's some issues that when you can get them in CNC status that maybe they have some potential transfer liability. It's called a fraudulent conveyance at the state level. This federal level is called a transfer liability under Section 6901. So we actually have a trial going in our office later this month on that issue up in Montana. So the government will look into those. But remember, you're going to have to give them everything. They're going to have to go out there, show them your financials, and if you have assets, they're going to make you liquidate them, and then they'll show you don't have ability to make any monthly payments. Your income is less than the expenses, some of which the government's going to use their tables, which are based on the Bureau of Labor Statistics, and the dollar amounts they allow you are very low, but that's what they use. So like I said, when you get placed in the CNC status, you don't have to worry about bank levies, wage garnishment, collection calls. They're not going to give you any new demands, but they are going to send you every year. They're going to send you a letter, and that letter is going to basically say, we're required to send you this notice, and it's going to tell you how much you owe every year, and it's going to be tacked on the penalties and interest. They didn't do that for a while, and then they came out with a statute that said they need to do that because people would be, let's see, in CNC status for a long time, and then right before the statute expired, they get contacted by a revenue officer and be like, oh, that $20,000 you owed us is now up to $80,000. And be like, whoa, wait a second, I had no idea that was happening. So now they'll send you a notice. My clients get those notices every year. I get the same email. And they're like, what is this? I'm like, don't worry about it. It's just a required notice to be sent to you. But remember this, the statute of limitations is going to continue to run that 10-year. Like I indicated before, some of these things are kind of redundant. Penalties and interest continue to accrue. They're going to file a lien against you. They haven't already done that. Most likely, not always, but most likely. And they're revisiting this in a couple of years. After the 10 years runs up, then the IRS just writes it off, and it just says it right in the transcripts, write off, and it gets written off. And I get a lot of our clients, we just kind of sit and wait, see what happens, and see if the IRS writes it off. Um, and if you really want to know what the statute expiration date is, you can actually even call the IRS and they'll tell you what it is. And you just ask them, what is the CSED and the collection statute expiration date? And they'll tell you. And then, we put that on our calendar, and the day after, we're good to go. Now, what happens is the IRS will file a tax lien, but you'll see in the tax liens there'll be a column where it says last day for refiling. So that last day for refiling, which is usually the CSED date plus 30 days, is usually that's the date that we look at. Then the lien, there's a box on the lien that it makes it a self-releasing lien. So once you hit that last day for refiling, if the government doesn't refile, then the lien is gone. It's self-releasing. So a lot of times we have to explain this to the title companies and stuff when my client then wants to go buy a house or wants to go sell a house, and they're like, "Well, we have a lien here," and I'm like, "Well, you do have a lien here, but that's self-released. Look at the box," and then we'll get them a transcript from IRS showing the IRS has written off the balance. So that's usually all it takes. But it takes a few phone calls because some of the people in the title company, don't really comprehend it because they don't see it that often. Let's go to the next slide.
Actually, before we do that, Jason, there's a question in the chat, and I heard you kind of touch on it, but it says wage levy or garnishment. How much can the IRS take? I heard you say it's a complicated calculation.
Yeah, it's a formula they take. I'm not going to go into it, but I mean, I've seen clients tell me it's as high as like 80%. So it can be a really high amount that they're going to take. So usually what my clients do is they quit their job because they don't have a choice because they can't live on, say, 20%. So they'll quit their job and go get another job, and then the government will have to try to find where they are at their next job. And they usually won't find out where they're at the next job until the next year when their W-2 gets filed with the IRS. So that's the kind of thing. Any other questions on the installment agreements currently not collectible?
Not on those. We got a question.
Okay. So let's go on to offers and compromises. So, if you're sitting there listening to radio, I don't know if anybody actually listens to radio anymore, like local radio, or if you're listening to national radio, or if you're watching television and you see all these ads, right? These ads are from all these national tax resolution companies. And they're always telling you, yeah, we can get you an offer and compromise. You're going to pay pennies on the dollar. Maybe. So an offer and compromise, I always tell everybody, it's just a math formula. So if you're not good at math, maybe you have somebody that's good at math and putting it together. But the forms the government uses, the calculation, everything else, I use everybody, big math formula. So basically an offer and compromise, it's just a settlement. It's just a formal agreement you have with the IRS where you say, look, I can't pay you the full amount, but I can pay you something. And the something is I can go borrow this money from a friend or a family member, is usually where they get the money. And because the IRS may never collect this in full. So the next question everybody always asks me is, well, what percent? And I always tell them it's not a percentage, it's the math formula. Sometimes, and it's going to depend upon how much you owe and how much equity you have in assets and how much you have in income and your expenses. So, I've seen offers where we offer 80 cents on the dollar. I've seen other offers where we offer 0.1% on the dollar. So, and everything in between. And people are like, well, I run through all the numbers, and when I run through all the numbers, it shows I can't pay them anything. So sometimes we'll just offer them a de minimis amount, say $500, and people are like, there's no way they're going to accept that. It's just not going to happen. I've gotten dozens of those accepted in those exact facts. So you just have to run through it. You have to know how to submit the offers and everything else. But remember, it's an offer and compromise. Let's just, on Monty Hall, let's make a deal and let's just settle this thing and what you can realistically pay. So, for those of you who are, my age or older, you probably know who Monty Hall is. Maybe some of the younger attorneys don't know who he is, but, let's make a deal. So what is IRS going to look at? They're going to look at what's called the asset equity table. Under the asset equity table, they're going to look at all your assets. Okay. And they're going to look at, for example, a house. If you still have a house, even though you came out of bankruptcy with it, they're going to look at your house and say, okay, we're going to go look at the fair market value of your house. Now, the big problem we have is trying to get certain assets valued, especially houses, because the IRS will go to Zillow and they will value your house based on Zillow. Well, we all know that Zillow can be too high or too low, or somewhere in between. You just don't know. I mean, I always tell people, go take a look online and see what it has your house for, and see whether you think your house is worth more or less than that. If you think your house is worth less than what Zillow has it at, then I would have you go out and get an appraisal of your house, so we can then submit to the IRS this appraisal, because Zillow is just kind of an estimate. But if you go at an actual appraisal of your house, that's going to give you a better idea. Especially now, I mean, we've seen some declines this last 12 months or so in house prices, because otherwise they're going to use Zillow, and it drives me crazy because Zillow is never right. Now, if Zillow has your house at a lot lower than what you think it's worth, then great, we're going to use that number, and we're just going to print up the Zillow, we're going to attach it to the offer and say, here you go. If you have so what they'll do with the house is they'll say, okay, let's say Zillow says it's worth $1 million, and that's the number. The government will allow you to take an 80% haircut on down to 80% haircut or 20% reduction, 800,000. They'll look at your any encumbrances, say 500,000, and say you have $300,000 of equity in that asset. They'll then take a look at your car, and usually we go to Kelley Blue Book. Usually whatever's the lowest number, which I think is usually trading value, we'll subtract whatever the encumbrance is on that, and then we'll back Kelley Blue Book. We'll take the dollar amount there, we multiply it times 80%, we subtract your encumbrance, and then the government gives you a levy exemption amount, which is $34.50 for each car. But if you're one person, they're going to only give you one car. If you're two people, they're going to give you two car, husband and wife. They're not going to give you any levy exemptions if you have other cars that are being used for your children or other family members. Retirement accounts, they're going to give you a haircut down to 70%, even though your taxes on those could be as high with the penalty as high as 50%. So they're going to take that down to 70%. If you have any loans on that, and they'll subtract that. Other brokerage accounts you have, they take 100% unless you can show you have a lot of built-in gains. You're going to have some taxes on those. Cash, you have cash in your bank account. They're going to take the cash dollar for dollar, and they're going to give you $1,000 levy exemption or reduction on that. Pretty much your furniture may have a lot of value, and they give you some other personal levy exemptions. So they're going to take all those assets, they're going to add them up, and that's going to be the starting amount for your offer and compromise under what's called the asset equity table. Next thing they're going to do is they're going to look at your income and expense table. Now, if you're a W-2 employee, pretty easy. We take a look at the last 3 months, or depending upon how the person is paid, we may look at the last 3 months and then look at the W-2 for the year before and do an average. And that will be your average income, and we look at it on a monthly basis. Then they're going to look at your expenses. Now, the first expense they're going to give you is, your living expenses, food, clothing, other miscellaneous items. They got a table, and depending upon the number of people in your household, you, your wife, and your children, you each get a dollar amount for that. It's non-negotiable. They just give it to you. Next thing they look at is they look at your housing and utilities. They're going to look at where you live, how many people are in the household, and they're going to give you no higher than the table amount, which is usually, pretty low. For vehicles, they're going to give you either a lease or a payment. They're going to give you a maximum amount for that, and then they're going to give you an operating expense on it. If you got a car that's more than 9 years or more older, they're going to give you an extra couple $100 on the operating cost of that vehicle because it's older and it's going to require more maintenance. They're going to give you other expenses. They're going to give you your actual out-of-pocket healthcare payments for any insurance. They're going to give you a table amount for your out-of-pocket healthcare. or your actual, whichever is greater, but you have to prove your actual if it's greater, and you usually give them like 3 months of sampling what that would be. They're going to give you your actual taxes that are being paid. So if you got a client that's making quarterly estimated tax payments, make sure they're making those payments state and federal, because you're going to get a deduction for it. If you're paying any spousal maintenance, child support, you're going to get those. Any secured debt, you're going to get those. If you're making payments, for example, to the state of Arizona Department of Revenue, other tax authorities are going to give you that. They're not going to give you a credit card statement, payments, minimum amounts, because those are kind of baked in some other things. They're not going to give you personal loans and the like. So they basically look at your income, they look at your expenses, and then they net the two. Okay. And for easy math, let's just say the difference is $100 and you want to make what's called a cash offer to the IRS. They're going to take the $100, multiply it by a factor of 12 or $1,200, and then they're going to add that to your asset equity table. There's a little bit more nuances to it, but that's kind of the basics of, offer and compromise. And that's usually what we call an offer and compromise based on data to collectability. That's the most common one. We have. Now, when you do file that, that's going to stop the statute of limitations. It used to be that statute of limitations would not stop, would not be told. So a lot of times we file offers and compromises. They were legitimate offers and compromises, but our theory was, hey, if we can stall them for 6, 12, 18 months, the statute expires and we just walk away. Can't do that anymore. Congress got smart. Doubts liability. You don't owe what the government says you owe them. So you can't, let's say the IRS made an assessment against you, and maybe you didn't get the assessment and be able to file something in the U.S. tax court, and you come back later and say, hey, I don't owe it, and here's my proof. Those are really, really uncommon. They're really kind of difficult to get through. So I probably see one of those for every 500 doubts of collectability that I see. Just really rare. The last one is called the Effective Tax Administration, ETA offers. These offers, these are dealing with really serious hardships. These are really disabilities. They're really old people that they have the ability to pay, but they're going to need these money for medical or other types of expenses. They're not going to be able to, pay this off because of all these other expenses they have, whether the government would allow them or not allow them under the tables. So I had a case. I've only filed one of these my whole career, and it was a really good one. I had a guy that was in remission from cancer, and he was using all his money to help with his treatment. And we filed one of these, and we told the government, said, look, this guy, we're being told that he can come out of this cancer at any time. Well, while we were in the offer trying to negotiate with him, the cancer came back and the guy died. And the government, because of the way he held his assets and everything else, the government ended up getting a very small amount versus what we were going to offer them in this ETA offer. So I found that, like I said, I've done one of those. I tell people, for the most part, the government doesn't know how to work those kinds of offers. So it's unlikely you're going to get those accepted. Really important things. And this is going to apply to also installment agreements and CNC status. You have to be current, and that means you got to have all your returns filed. So everything needs to be filed. If you're on extension, that's fine, but you need to be current with all your filings. And the look back period is usually going to be 6 years. Number 2, you have to be current with making estimated tax payments quarterly if you're required to do that, and or sufficient withholdings. So, if the person goes to their employer and fills out the W-4 and has 10 exemptions, and they have, a small amount being taken out at each pay period, that's not sufficient. And you can't be in bankruptcy, obviously. Everything gets frozen in time when you're in bankruptcy. So those are impediments to filing an offer and compromise. That is, you have to be current with filings, making your payments, and no open bankruptcy. The government doesn't want you to start pyramiding your taxes with filing more returns in the future you still owe. Next slide. Questions. I went through a lot of material in the last 45 minutes. Um, like I said, each one of these areas we could really get into the weeds, but these are the things you kind of clients need to know about when they're coming out of bankruptcy, or these may be things that you may want to look at before they go in bankruptcy. So if tax is your only reason for going in bankruptcy, then you should be looking at some of these other things for purposes of trying to resolve your debt with the IRS. But if you have other things, personal guarantees, other debts that you're trying to get rid of, credit cards, etc., um, then you can still look at these options that wouldn't get discharged in bankruptcy because of timing or maybe the type of tax. Because you can also you can do all these types of things for trust fund taxes also. So come out of bankruptcy, you still have trust fund taxes from your business, and these taxes are something you can look at one of these collection alternatives with the IRS. So any other questions?
There's a question in the chat, Jason, from Hal Campbell about the valuation, in particular, of a home when there's been a tax lien filed. He says tax lien filed prior to bankruptcy, after discharge, is the IRS limited to the equity in the house at the time of the bankruptcy filing, or can they seek any post-filing appreciation?
That's a really good question. I don't know the answer to that. Um, I think what they would probably look at is they would probably look at whatever the value is. I'm spitballing here. But I'm thinking they're probably going to look at whatever the value is at that time that they're talking to you. Because what happens is if you don't work out something, what are they going to do? They're going to do just like anybody else. They're going to take you to foreclosure proceedings in essence. And the way the IRS does that is they will file an action in federal district court, and you're going to, they're going to have a United States attorney assistant working on that, and they're going to go and judicially levy your property. Um, so they're going to be, probably looking at that time because, and they don't want to do that because they have to go through the whole court process, and then there's certain redemption periods, and then they have to list the house and sell the house. And when they list in the house, they're always listing the house at usually 60% of the fair market value, and there may be other lien holders that are ahead of them. So it may not be that they even get any money out of it, depending upon the other lien holders and the value of the property, what they might get. Because, like I said, they're going to list the property. There's websites the IRS has when they list properties around the country, and I actually went to one just for to see kind of what happens. And it was in person when they used to do this, probably 15 years ago, and there was a lot of people that showed up. And I showed up, I was thinking, oh, maybe I can see if I can pick this thing up at 60 cents on the dollar. It ended up going for about 110% of the value, which was shocking to me. Um, but some people think they're going to go to an IRS auction, they're going to get a good deal. Maybe, maybe not.
And when you're preparing the OICs, the offer and compromise, I presume you're valuing assets as of the time you're preparing that, perhaps
Right.
regardless of circumstance.
Right. So you're going to take those assets as of that time. Now, it could take 6 months or longer before the IRS looks at something. So you're not required to tell them if things have gone up in value. Okay. But if things have gone down in value, you should be telling them about that and giving them current information so you can help try to reduce it. It's up to the government to say, hey, give me current brokerage statements because, maybe you bought SanDisk and it's gone up, 30 times since you bought it last year. And, it wasn't worth a lot then, but it's worth a lot now. It's up to the government to inquire with you on those assets if if they want to look at those at different values. But I rarely, I mean, maybe 1 in 500, I'll get the government to say we want to look at current values. It just doesn't happen.
Thank you. Another question in the chat from Martial Lamb. Does the IRS refuse an OIC based on a belief that the person will make more money later or receive more assets later?
Yeah, so there's a question on the offer. It talks about whether or not you're a beneficiary of any trust or anything else like that, and that's always kind of a difficult issue because depending on what kind of trust it is. So if it's a trust where you're only required to get the interest from it and you have no principal right to it, it can be difficult. And the government a lot of times they'll seem to think that, well, you're a member, you're a beneficiary of a trust that has $1 million in it, and because you have that, then you should You should be able to take that asset and sell it and give us all our money. It's like, well, no, somebody else is the trustee. And because somebody else is the trustee, I have no right to any principal from that. All I have a right to is the interest, based on the way the trust is written. And therefore, no, I can't get to that money. And it just gets really difficult as far as what they think you might make more money in the future. We haven't really had those kinds of issues. It can be more difficult and I didn't get into this because it's a lot more complicated, is when somebody has a business, trying to determine what somebody's monthly income is. Because from year to year, businesses, have different amounts of income they're making, net income. So they'll usually take a look at a 3-year average, or if your last 12 months is higher than the last 3 years average, you'll look at the last 12 months. So sometimes that can make an offer more difficult based upon those types of issues.
We got a few more questions in the chat, and I'm taking them a little bit out of order, but I promise I'll try to get to all of them. If not, you'll speak up for me, for yourself. From Jim Kahn, when the IRS sells your home for 110% of value, who gets the excess? I bet I know the answer.
The IRS.
Take as much as they can get, right? But I'm assuming only as much as they're lien, but I'm guessing
Yeah.
most of these liens are pretty big and not enough to
Yeah. Usually.
proceeds are not enough to satisfy.
Yeah. I mean,
Sorry, go ahead.
that doesn't happen very often. I mean, that was a strange circumstance.
Earlier, from Andrew Nemeth, question on your first slide, you had a comment about getting transcripts prior to the filing. And he says, which tax transcript should we get? Tax return transcript, tax account transcript, or record of account transcript?
You might get account transcripts.
The
So
tax account transcript?
Yeah, you're going to get account transcripts. That's going to show you all the detail.
I think the record of account, Andrew, combines the third option there. I think it combines the prior two. The transcript website does outline what information is on all three of those. So, and then another
Yeah.
question about transcripts, and that is about timing. Scott Greaves says, how can we find out the assessment date for tax years that are beyond available transcripts?
Well, I mean, the transcripts should all be available if there's a balance due. If there's a balance due, those transcripts will be available. If not, if for some reason you can't get them, I'd have the taxpayer go down to, and you have to make an appointment because they don't want people not to have an appointment. You can go to one of the IRS offices, either Phoenix, Mesa, or Glendale, and ask them for an account transcript on what you're, for that year, and they'll have them, and they have to have them because that's what they use for purposes of collections.
I think, Scott, the website I know says only X number of years available for this kind, but as Jason says, they're available. They maybe just not available online. I think you can even get them through that 4506T form or whatever that's called. Different from just being able to grab them from the website.
That's usually a tax return transcript, the 4506T.
Hmm.
Usually they're, like I said, I haven't, usually when it says they're not available because there's a glitch in the IRS system. So I would tell people, I would send my clients down and go actually get the actual transcripts if for some reason I can't get them on e-services. But they're gonna be somewhere if you have a balance. They're not going to, even if they're 15 years old, because the tax year is 15 years old because maybe the assessment happened later and there was bankruptcies in and out, offers and compromises, or other things that could extend the statute of limitations.
Thank you. And then a question, and then a follow-up on the same topic from Doug Price. He says, IRS does not use Arizona exemptions. Where in the Internal Revenue Code can we find the exemptions used by the IRS, which I believe are very limited? And then he follows up and says, I think the exempt from levy exemptions are in 26 USC section 6334. Does that sound right?
They're actually right on the form. The form 433 A paren OIC has them right there on the exemptions. So they're right there. And the exemption, you get the $1,000 for a bank account, $3,450 per car, and then there's certain other amounts for personal possessions, tools, and stuff like that. They're right there on the form, so you don't have to guess.
That's helpful. And then I think this is the last comment or question rather in the chat from Scott Greaves. If I've overlooked you, please unmute yourself and speak up. But Scott Greaves says, if a non-bankruptcy client owes for several past years, can payments be applied to more recent years, or must oldest years be paid first?
So if you're on an installment agreement, the IRS is going to apply whatever is their best interest. And that means they're going to apply those payments whatever year the statute of limitations will expire soonest.
Does that mean If you voluntarily pay, you can mark your check
You make your own voluntary payments. You can apply them wherever you want.
by specifying on the check or cover letter or both. What do you recommend?
I'm sorry, say that again.
By specifying on the check or in a cover letter or both, or what do you recommend?
You know, the problem with checks is the government usually screws up a lot of times in designating, and you designate them, and you can designate on your check, which usually we attach a letter. But I always tell people the best way to do it now, because IRS actually, I mean, they're still technically accepting checks, but they don't want to have checks anymore. They don't want to get checks. They don't want to receive them. They want to go all, through e-services, which is going to be a problem for a lot of people that don't have e-services or don't have access to computers. But I tell people just go to e-services, make the payment. You can click right where you want it to go, and it won't be a problem. And that's how it should get applied. But a lot of times, we're dealing with like clients with their businesses, and they'll have an employee doing this, and the employee usually screws it up. So make sure if it's your business, you do it and you make sure it's done right because it's going to get screwed up.
Thank you, Jason. I don't see any other questions in the chat. I did just post the CLE certificate in that chat. Just another reminder, please grab and save that certificate now or forever hold your peace. It will not be posted to the website or any other place. So again, please grab and save that CLE certificate for yourself. Be sure the .pdf is at the end of the file name that you saved so that it will properly open for you. I will say thank you again, Jason. This was wonderful. All of our practices touch tax stuff, and I will continue to say I don't give tax advice. Go talk to Jason, but this is still very, very helpful in us, and at least being able to spot these issues and be able to gather and help the clients gather more information before and after filing.
Thank you for having me. Everybody have a wonderful Mother's Day weekend.
Thank you. You too.